All right, I want to bring in now Guy Relford, a Second Amendment attorney out in Indiana. Guy, welcome to the program.
Good morning, Grant. It's great to see you.
Great to see you too. So this is great news. Not an electrifying case by any means, but it certainly could have far-reaching effects.
It could, and I think you made a really important point just now, Grant, which is, we've seen other cases around the country, including the Peruta case out of the Ninth Circuit that you and I have talked about. And in that case, the Ninth Circuit held that there is no right, no constitutionally protected right to carry a gun outside the home and at all. And since we are talking about guns outside the home in this New York City case, we could have a very, very narrow ruling, or we could have a much broader ruling that may then either cast doubt on or even overturn what the Ninth Circuit did in Peruta, again, saying that there is no constitutionally protected right to carry a concealed firearm outside the home. So I'm hoping for a ruling that clears up some of the clearly, I think, misguided decisions that we've seen out of other courts.
So I think you'd agree. I've talked to some other attorneys on this subject, and that these lower courts, these left-wing lower courts in particular, go through these legal hurdles to do everything they can to ignore Heller and McDonald and some of what was spelled out there. I believe this case will at least give lower courts direction, and maybe mandatory direction, with how they're supposed to apply the law when ruling on these things.
You're right, Grant, and there are a lot of sort of sub-issues in play in this New York City case, like what level of scrutiny should a statute that's alleged to be unconstitutional under the Second Amendment, what kind of scrutiny, what's the legal analysis a court should go through in determining its constitutionality, and there's a lot of ambiguity on that issue, and the lower courts, to your point, have totally bastardized what the Supreme Court did in Heller. And I read the petition for certiorari, the request of the New York State Rifle and Pistol Association for the Supreme Court to take this New York City case, and they're focusing on that because the Second Circuit, in upholding the silly law, as you mentioned, you can't even take your own gun in your own vehicle outside of the city. In fact, the only place you can transport it outside your home, if you have one of these premises licenses, is to one of 7 shooting ranges inside the city of New York. A city of 8.5 million people, you can only take your gun to one of 7 ranges. So once we get into these issues where the possession of a gun outside your home and whether there's constitutional protection for that and what the legal analysis should be, I think we could clarify a lot and really take a giant step forward in protecting the Second Amendment because of how badly lower courts have gone through mental gymnastics trying to avoid an actual application of the real ruling in Heller.
I think you've got to ask the New York attorneys in this case one simple question. How is it not an effect on public safety to take your firearm to a range within the city, but it is an effect on public safety to take it out of the city up to your second home or a range outside of the city? You're driving it one place, it's dangerous, one place it's not. There's no way they can answer that question legitimately.
No, I think you're right. And even the claim of how they're promoting public safety through this restriction, I kind of chuckled when I read it, because what they're saying is, well, gosh, if we're going to let people transport a gun out of the city, so they're going to have them in their cars, even though the requirement, by the way, is it's locked in a container, it's unloaded, and it's stored separately from any ammunition. So your gun's in that condition in your car, and what they're saying is, well, you could have a road rage situation where these people, because now there's a gun in their car, they're going to suddenly access it, unlock it, load it, and use it in a road rage situation. And the question you ask is a great one, which is, well, okay, if we buy that, I think it's preposterous, but assuming we buy that, why isn't there the same issue when people are legally then driving to one of these 7 gun ranges? And oh, by the way, how many times have we seen that? Right. So it gets a little laughable. And the Second Circuit, again, they had to absolutely do mental handsprings. They had to contort the Heller decision beyond recognition in order to reach this result. And I'm glad the Supreme Court took it, and it's satisfying. Here, it's been, like you said, it's almost been a decade. We've had something like 35 First Amendment cases go up, something like 25 Fourth Amendment cases, and hey, we're finally going to get a Second Amendment case. So we'll see what they say, but it's exciting.
Yeah, it absolutely is. Guy Relford, as always, thank you, buddy. I appreciate you helping me break it down.
Great to see you. You enjoy your day.
All right, you too.